Hello friends, in today's session we are going to discuss a case Naresh Pandey vs. State of Madhya Pradesh, reference A.I.R 1974 SC 35. Mr. Naresh Pandey was accused of threatening Dr. Majumdar on May 11, 1970. The trial court ordered his release on probation under Section 4 of the Probation of Offenders Act 1958. The Session Court altered the sentence, imposing a fine and imprisonment. The High Court rejected the appeal against the Session Court decision. The Supreme Court held that the objective of the Probation of Offenders Act is to reform offenders, not to make them more serious criminal. The court found that the appellant should not have been deprived of the benefit without solid reason and upheld the lower court's order. Under the Probation of Offenders Act, offenders under the age of 21 who do not commit serious crime should receive correctively punishment. The act was enacted with the aim of keeping young offenders away from the company of hardened criminals and rehabilitating them. Now we will read this case in detail. Naresh Pandey, Appellant vs. State of Madhya Pradesh, Respondent. Reference A.I.R 1974, Supreme Court 35. Subject of the case stated that the benefit granted under Section 4 of the Probation of Offenders Act 1958 cannot be altered by the appellate court without any valid reason. If an offender has been ordered to be released on probation, the benefit granted to them cannot be revoked, keeping in mind their good conduct and circumstances. Fact of the case: the appellant was charged under Section 506 of the IPC for the offence of criminal intimidation, as he illegally threatened Dr. Majumdar, a woman, on Monday 11, 1970. Trial Court. The trial magistrate found the appellant guilty under Section 506 Part 2 of the IPC and ordered that the appellant be released on probation for good conduct under Section 4 of the Probation of Offenders Act 1958. For this, the appellant was required to execute a personal bond of ₹700 and be released for a period of 1 year with a surety of the same amount. Session Court. On appeal, the additional session judge Jagdalpur modified the appellant's sentence to Sentence 506 Part 1 of the IPC. The learned additional session judge cancelled the trial court's order of releasing the appellant on probation and instead imposed a fine of ₹50. In case the fine was not paid, the appellant was directed to undergo 7 days of simple imprisonment. High Court. The review petition filed by the appellant against the Session Court's decision was dismissed by the Madhya Pradesh High Court, Jabalpur. Supreme Court. The appellant filed an appeal in the Supreme Court with special permission or leave. The Supreme Court held that the purpose of the Probation of Offenders Act is to prevent the offender from becoming a more serious criminal, as being in prison with hardened criminals could lead to further deterioration due to their influence. This goal is a significant attempt in the field of modern criminology towards a corrective approach. Therefore, it is more appropriate and just to give corrective of punishment to first time offenders and young criminals rather than punitive punishment judgment. Neither the session judge nor the High Court provided a clear explanation as to why the appellant should be deprived of the benefit granted under Section 4 of the Probation of Offenders Act 1958, under which the trial court had released him in the absence of valid reason. In our view, the appellant should not have been deprived of this benefit. Accordingly, we accept the appeal, set aside the decision of the High Court, and direct that the appellant be released on probation for good conduct under Section 4 of the Probation of Offenders Act as ordered by the lower court. Legal principle pronounced. The principle of modern criminal jurisprudence is that no person is a criminal by birth, rather, they become a criminal due to the influence of social and economic conditions. The Probation of Offenders Act was enacted with the aim of reforming such offenders. Under this act, exempt in specific circumstances, the court does not have the authority to sentence offenders under the age of 21 to imprisonment unless it is a life sentence. This provision was made with the objective of adopting a corrective approach to reintegrate offenders into the mainstream of society. Under Section 6 of the Probation of Offenders Act 1958, only those offenders who are under the age of 21 and whose crime does not carry a provision for life imprisonment can avail of this benefit. It does not matter if a lesser sentence could have been imposed for the offense. The Probation of Offenders Act 1958 was enacted with the objective of keeping young offenders away from the company of hardened, dangerous and notorious criminals so that they do not turn into hardened and dangerous offenders themselves. Watch full video. Please share and subscribe my channel. Thank you.